A last will and testament in Connecticut, in most cases, can be created rather easily and often without seeking legal advice from an expensive lawyer. Wills successfully document how an individual wishes to distribute their assets upon death, allowing for peace of mind and avoiding court proceedings. This video will cover the importance of wills and what happens when one isn't created, what's included in a will, legal requirements in Connecticut, and how and where to create an official will. Let's begin. What is a will and why is it important? A last will and testament, simply known as a will, is a document that communicates an individual's instructions on how to distribute their property among family, friends, and other beneficiaries after their death. It's highly recommended for all adults to have a will, especially those in the later stages of life. Now, what occurs if no will is left in Connecticut? A person who passes away without a will unfortunately loses control over who inherits their property. The state of Connecticut, through its probate process, will dictate how the deceased property is handled. Usually the assets are passed to the deceased spouse or children, but even then disputes between potential heirs can arise that likely have to be reconciled in lengthy probate court proceedings. One can avoid this by making a clear will document, and often without an expensive attorney required. A person of sound mind can draft his or her will in Connecticut, which contains the following essential information: their full name and residing address, the information of their personal representative, also known as the executor, who will distribute the assets accordingly, the names of all beneficiaries, and a thorough list of the property each shall receive, any additional terms and conditions, and the signatures of the testator and 2 witnesses. And finally, let's review some legal requirements in Connecticut. Last will and testaments in Connecticut must be signed by the person to whom the will belongs, known as the testator, in the presence of 2 witnesses. These 2 individuals must be competent adults, and though optional, it's recommended that witnesses be disinterested parties. Disinterested parties are individuals who do not stand to personally benefit from the will or receive a share of the testator's estate. Once created and signed, the document will be legally binding. Multiple copies can be made and given to the executor of the will and another trusted individual for safekeeping. We're eForms, the biggest database of legal documents. We've created extensive last will and testament templates for Connecticut that are quick and easy to fill out. Our software generates an official document after you select your desired will instructions. Click on the link below to begin creating your will now. And don't forget to like and subscribe for more daily videos.